Got a question asking if landlord and tenant walk the rental unit, right, to identify potential problems that the tenant has raised to the landlord, and then a tenant basically, or a landlord basically says, okay, we're going to send maintenance to fix it on such and such date, and the tenant says no, you can't fix it while I'm not here. Is that legal? Hi, my name is Rob Wells. I'm the landlord warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, let me answer the first question, okay? Does a landlord have the right to fix items in a home when a tenant's not home? The answer is legally under Civil Code Section 1954. If the landlord provides the tenant written notice of their intent to enter, as long as the landlord has followed Civil Code Section 1954 and is not purposely trying to harass the tenant, if the landlord gives lawful notice, it's at least 24 hours away, it's reasonable, basically, then the landlord doesn't need the tenant's consent to enter the actual property to facilitate the repairs. Now, I see a lot of disputes like this, and in the past it's come up because the landlord and tenant are butting heads with each other. Sometimes it's like both parties being stubborn. What I try to tell landlords is, listen, I would rather have your tenant, have voluntary compliance. Let's get everyone be in agreement about when these repairs are done. Okay, I generally try to, keep repairs during normal business hours between Monday through Friday, 8 to 5. Some folks say 8 to 6, type deal. And I try to get both parties to consent to the repairs, okay? Because hey, listen, the name of the game usually on these habitability issues or maintenance issues is to get the repair taken care of, so we can move on with life, okay? That being said, sometimes disagreements occur. A tenant may want to be present when the repairs are going to be made, and I generally tell my landlord it's okay. I would try to accommodate that request so we can get the things done and so forth. Now, from the tenant's perspective, a couple of things. You can't interfere with your landlord actually doing the work, okay? Because I've had tenants before try to stipulate you got to use like certain vendors, or you got to use a licensed contractor to do X, Y, and Z. That can land you in hot water. Again, because the law doesn't require that the tenant to dictate to the landlord how things are done. Now, obviously, landlords, you're going to want to make sure your repair people do stuff the right way, because if your tenant's injured or it was done in a substandard manner, you could probably be looking down a lawsuit basically as to the shoddy work that your handyman or whoever has done, okay, or your worker that you hired, okay? So you don't want problems coming up that way as well either. I also try to to encourage parties to go like, listen, okay, give me a couple of dates and times, like in 2-hour blocks basically, that we can kind of do this work with during the weekday hours, okay? Because most vendors are only going to be able to come like on weekdays, right? And they usually give you a band of time between like 8 and 10, that type of deal, or whatnot. And that way we can kind of come to an agreement at least to like certain times and be reasonable with those times, okay? Because I will say that, if a tenant gives you unreasonable times to do repairs, such as like you can only come on Friday between 4 and 5, that's unreasonably restricting the landlord from doing the repair that you're complaining about. And that actually could backfire on you as well, too, because the issue might not be as serious as you're complaining about it to be if you're kind of letting the restricting people from doing what they need to do, okay? It could just, both parties can end up in court, particularly on an eviction for failure to give access, and it just, on both sides, it costs legal fees and costs and so forth. So probably not a good idea if you can avoid it, okay? So hope those are some considerations I would consider. But technically, a tenant doesn't have to be home as long as landlord has either written consent already or has given notice. So landlords, if you're facing a situation where you're trying to get access to a unit and you've tried reasonable efforts and documented those items, but it's still not working and you need help dealing with the situation, feel free to reach out. We might be able to help out. Go to our profile and book a free case review session. There'll be a couple of questions asked to see if we're a good fit or not. But put your questions, comments down below. Try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.